If you're over age 50 and you plan to depend on your VA disability compensation for financial security in your latter years, a claim denial can put that and your other hard-earned benefits at risk. The VA follows strict rules under the Title 38 of the Code of Federal Regulations in the VA Adjudication Procedures Manual, the M21-1. And missing just one requirement can cost you the benefits that you've earned. In this video, I'm going to walk you through the top 10 common reasons claims are denied and exactly how you can prevent them from happening. VA claim denials are not random, they're procedural. The VA must first confirm 3 legal elements before awarding benefits under Title 38 of the Code of Federal Regulations. The first is the veteran must have a current diagnosed disabling condition that is recognized by the Veterans Administration. The second, the veteran must have an in-service event that caused the injury or the illness, which is the diagnosed condition. And third, there must be a medical nexus that is connecting the in-service event to the veteran's diagnosed condition. And failing any one element of these 3 can result in a denial. So let's jump into the top 10 reasons this happens and how you can prevent it from happening. The first is the veteran's lack of having a current diagnosed condition. Under the 38 CFR 3.303, that outlines how the VA determines service connection for disabilities, and that means that the VA requires evidence showing that your condition began or was aggravated during your military service. If your service treatment records don't document your illness, injury, or event, it becomes much harder to prove your claim. The VA cannot grant benefits without a current documented condition. So the first thing you want to make sure you do on your claims journey is obtain a formal diagnosis of your condition that you're going to be claiming if you don't already have one. And also include all VA and private medical records pertaining to that condition as part of your claim submission. And if your claim is denied due to a lack of diagnosed condition, you can submit a supplemental claim with updated medical evidence to support your position. The second is going to be lack of in-service evidence supporting the event and your diagnosed condition. Under the 38 CFR 3.303A, which is a regulation that explains the VA's requirements to establish service connection for disability, the VA looks for evidence showing your medical condition began or was aggravated during your military service. And this regulation is the foundation for proving that your current diagnosis is linked to your time in service, which is essential to avoid denial for your claim. So simply stated, no supporting evidence in your service treatment records equals a higher chance of denial, which is common sense. So how do you avoid this from happening? There are a few things that you can do that can help mitigate this risk. The first is obtaining buddy statements and providing them as part of your claim. Under the 38 CFR in the M21-1, the VA identifies a buddy statement is a written account from someone who served with you describing what they saw and know about your in-service event, injury, or symptoms. The VA accepts these as lay evidence when official records are missing or incomplete. Make sure the statement is detailed, signed, and explains how the person knows your situation. You can also provide personal statements. And a personal statement is simply your own written explanation of what happened during your service, your symptoms, or your experience related to your claim. The VA uses these statements as evidence, especially if official records are missing. Be clear, be specific, describe what happened, when and where, and how you know it. If your account matches other evidence, it can really help your claim get past this hurdle. Under the 38 CFR 3.159, lay evidence refers to any evidence provided by a person who does not have specialized medical training or knowledge. According to 38 CFR 3.159, lay evidence can include written or oral statements from the claimant, family members, friends, or fellow service members describing their observations or knowledge about the claimant's condition, symptoms, or experience. These statements are considered credible if they relate to matters that the person observed or personally experienced and are used by the VA to help establish facts when medical records or other official documentation is incomplete or missing. So if you are denied due to a lack of evidence, you can file a supplemental claim and provide these statements, additional unit records you have been able to obtain, or additional evidence you've been able to secure throughout the process. The third issue is the veteran's lack of establishing a medical nexus connecting the in-service event to the diagnosed injury or illness. Under the 38 CFR 3.303 subsection D, this regulation allows service connection for a disability even if it first appears after service, as long as the evidence shows that it is related to your time in the military. In other words, you don't need to have symptoms or a diagnosis while you're serving if a credible medical opinion or other evidence links your current condition to something that happened during your service. The VA can still grant your claim under those conditions. This is especially important for conditions that develop later in life, as long as there are clear connections to your service that can be established. A diagnosis alone is not enough. The VA requires a medical link between the in-service event and your current diagnosed condition. So if you were denied due to a lack of a nexus between the in-service event and the diagnosed condition as a result of your VA C&P examination, you can get a third-party independent medical opinion, which will be a private DBQ in a nexus letter. That must indicate that your illness or injury is at least as likely as not linked to your in-service event. And then you can submit this new information to the VA in a supplemental claim. The fourth reason veterans get denied is missing a compensation or pension exam. Skipping or missing an exam can trigger a denial. So to avoid this, you want to make sure that your address is always up to date. You want to attend or reschedule any VA C&P exam immediately. And if you are denied, request rescheduling with a good cause explanation. Now, a good cause explanation, according to the 38 CFR, means giving a simple, honest reason why you missed your exam or did not submit needed information. According to the 38 CFR 3.655 and the VA's M21-1 manual, a good cause might be things like being sick, having an emergency, not getting the exam notice, which is not a real good one, so keep that in mind, or having transportation problems getting to and from the C&P exam. If you clearly explain your situation and the VA finds your reasons to be reasonable, they may allow you another chance to attend that exam. The next reason that veterans are commonly denied is their condition is not chronic or active. According to the 38 CFR 3.303 subsection B, a chronic condition shows ongoing symptoms or impact, not just temporary or resolved issues. And an active condition means symptoms are currently present. To qualify, medical evidence must show the condition persists or is actively being treated. If the condition has resolved, the VA is unlikely to approve the claim. So to avoid this from happening, make sure that you document the continuity of symptoms and show active treatment and functional limitations that you're currently experiencing, because documentation is key when it comes to VA disability compensation. The next reason that veterans are a lot of times denied is they're filing the wrong type of claim. Under the 38 CFR 3.310, it says filing the wrong claim type refers to submitting a claim under the incorrect legal basis, such as direct service connection instead of filing it as a secondary service connection or vice versa, which can result in a denial. Under the 38 CFR 3.310, a secondary service connection means the claimed disability is caused or exaggerated by a other service-connected condition. If you mistakenly file as a direct service instead of a secondary service, or do not clearly show the relationship between the conditions, the VA may reject your claim. Always identify if your claim is direct, secondary, or aggravated, or presumptive, and file accordingly to avoid a denial. So this will be something you want to have a good conversation with your qualified accredited VSO, your accredited veterans attorney, whoever you're working with, to make sure that you're filing the claim correctly under the correct condition. The next and the seventh reason that veterans are denied is they're filing for presumptive conditions, but they do not meet the requirements of the presumption. Under the 38 CFR 3.307 and 3.309, to qualify for a presumptive condition, a veteran must meet specific service location and time frame requirements related to certain exposures or events. If these criteria are not met, the claim for presumptive condition will be denied. So in summary, make sure that you verify your eligibility, such as where and when you served, before filing for your presumptive condition to avoid a denial on this basis because you are deemed ineligible. For example, certain presumptive conditions like the Gulf War or Agent Orange in Vietnam require service location and time frames of service in those locations to determine eligibility. So to avoid this from happening, make sure that you go to va.gov and verify what is the eligibility requirements to file for a presumptive condition to make sure that what you're filing does indeed qualify. The next reason veterans are denied is insufficient evidence submitted to the VA supporting their claim. Under the 38 CFR 3.159, the VA does have a duty to assist, which means the VA must help the claimants obtain evidence to support their claims, such as service treatment records or medical opinions. However, veterans are still responsible for submitting key documents and cooperating with the VA to ensure that all necessary evidence is gathered. So to avoid this from happening to you, include all relevant medical, service, and private records. And don't rely solely on the VA to gather the evidence. Even though they do have a duty to assist, that duty to assist will only go so far. The next reason for denial is credibility issues, which is mismatched statements or inconsistencies in your file that can lead to a denial. To avoid this, make sure you review your military records and your medical records, military and private, before submitting your claim to the VA. Make sure the picture is making sense to avoid further confusion and ensure statements and medical records are consistent and accurate throughout. And the last condition we're going to discuss today as to why veterans are denied is the conditions they are applying for are not considered severe enough to be rated. Under the 38 CFR Part 4, Schedule for Rating Disabilities, sometimes a claim isn't denied. It's rated at 0%, which may reduce your overall compensation expectation. So to avoid this, make sure that you document your symptoms and functional impact the diagnosed claim condition has on your ordinary daily life and your occupational existence. And it's important to know that if you are denied under the Appeals Modernization Act, veterans have three different options to mitigate this. First is you can file a supplemental claim, which is where you're going to be providing new evidence. Second, you can request a higher level review, which is no new evidence submitted, but there'll be a more senior person looking at the overall claim. And the third, you can go to the Board of Appeals. And you have a 1-year deadline from the time of your claim decision to enact one of these. So if you found today's video useful, please take a second, subscribe to my channel, put a like on the video to send it out to more veterans. And as always, I appreciate you watching. I'm Mike, and I will see you on the next episode.